Members of the jury, on the 27th of May, 2007, these plaintiffs occupied the fourth floor of the premises known as 175 Main Street. That building is a tenement house building within the meaning of the tenement house law. Consequently, it was the duty of the owners to keep those premises in a state of repair. It has developed from the evidence that 3 or 4 persons were owners. Only one is sued here, so we have to deal with him only on the question of liability. Now, the plaintiff's wife claims that on the day in question, sometime in the afternoon, and you will recall just what the time is, that while she was in her kitchen, a piece of mortar fell from that ceiling in the closet which has been described and struck her on the head and shoulders, and as a result of coming in contact with the material which fell, she has sustained the injuries of which she complains. She has brought an action against the defendant to recover her damages on the theory and on the claim that that defendant was negligent in failing to repair those premises and keep them in a state of repair. Her husband has instituted an action also to recover his damages, that is, the expenses to which he has been put in caring for his wife, and for the loss of her society and companionship, and of that I will speak a little later. Now, before the plaintiff can recover here, they must establish by a preponderance of the evidence, and by that I mean the greater weight of the evidence, 3 propositions. First, that the defendant was negligent. Second, that the wife herself was free from any fault which brought about this accident. And last, their damages. Now, if they fail to convince you as to any of these propositions, then your verdict in each case should be for the defendant. Negligence is a relative and not an absolute term. What may be negligence at one time and place and under one set of circumstances may not be negligence at other times and places and under different circumstances. Now, before the defendant can be charged here with the liability, it must be shown that he had notice of the defendant's condition of that ceiling, actual notice or constructive notice, and which I speak of constructive notice, I mean that the thing must have existed for such a period of time that a reasonably careful and prudent man would have delivered or discovered and remedied and corrected it. Now, in this case, the plaintiffs are relying on actual notice. It is the claim, I believe, that at least a month prior to this, that the attention of the man, Mr. Taylor, was called to that defect, that it was pointed out to him. Mr. Taylor apparently was an owner or a part owner, but whether he was an owner or a part owner, if he was a collector of that rent, and if he went to that apartment to collect the rent, then notice to him would be notice to the owners, including this defendant. That is the plaintiff's claim on notice. They are predicating their cause of action on constructive notice. They are doing it on actual notice. That is their claim. You recall the testimony of the wife as to how this occurred, the way that the mortar fell down and struck her, what position she was in. The defendant raises the question that that was a physical impossibility. Now, you have had pictures exhibited to you, certain measurements have been given to you by these witnesses, and you have had a description as to how this thing is said to have occurred. I think there can be no doubt about the fact that the plaintiff was injured in some way, unless she is a perjurer, unless her daughters are perjurers, unless these young women who went there are perjurers, and the doctor is a perjurer. She certainly had some injuries, unless these people have all come in here and perjured themselves. It is not so important whether she had these injuries, gentlemen. But the important thing for you is how she received them. Did she receive them in the manner in which she has described, or did she meet with an accident in some other way and sustain the injuries? That is your first proposition, gentlemen. There is a dispute in this evidence about practically everything in it. The plaintiff claims that after having sustained those injuries, she went down to the Taylor apartment and notified Mrs. Taylor, as I recall the testimony, and, gentlemen, possibly I may be mistaken in that respect, or in any other. It did.
Yeah, pretty well.
It was. How fast did you was?
177.
Huh?
177.
Gee, I thought it was faster than it was. It would see 23 times 35 is 15 and 11, 9, 6, it's 5. It's 800 words in 5 minutes.
So that's
160.
60.
Couldn't be much more because you got it.